Welcome to the Synergy Sessions, Aging Smarter in Silicon Valley. I'm your host, Tom Nelson, and I know firsthand as a family caregiver and part of the sandwich generation how tough it can be to take care of your aging parents while balancing your own life, career, and family. We'll bring you the experts and information necessary to help make your life a little bit easier and you a little bit smarter. Synergy Sessions is brought to you by Synergy Home Care, bringing you personalized in-home care and peace of mind to Silicon Valley families. I really do hope you enjoy the show. Well, hi, everybody. Welcome again to the Synergy Sessions, Aging Smarter in Silicon Valley. Today, I'm super excited to have Jeannette Marsala to talk about the importance of estate planning. She's a life planning attorney with the Marsala Law Firm, and her tagline, which I'm very excited about, is heart-centered estate planning for peace of mind and a prosperous. I'm very much into hearts and heart-centered business. As you can see, my heart with Synergy. Welcome, Jeannette. I'm so happy to have you today on the podcast. Excellent. Well, why don't we just go ahead and start out? I think a lot of people, the reason why I think it's so great to have you on here is that estate planning is just kind of this thing that's out there that people think they probably should do and look into. So maybe let's just start at just what do you do in your role as a life planning attorney and, kind of the primary function of your firm and how you help people with their estate planning?
Yeah, so what I do is I help create plans so that families can take care of one another if one of them gets sick or become incapacitated or disabled, and make sure that everything is smooth after they pass away. So, in essence, I'm trying to keep families out of court, out of conflict, make sure families are prepared for the future. So, a lot of times I will market myself as a life planning attorney, mostly because I think a lot of times when people think of estate planning, they think death and dying and doom and gloom. And for me, it's really about the opposite. It's about the people who are here. It's about us when we're still alive. It's about leaving our legacy, connecting with one another. So that's really, I like to kind of flip it a little bit and say it's life planning versus estate, because estate only really happens after you're gone. And I think it's so much more than that.
Right. And I think the estate is the stuff, whereas the life is the people. So that's a really great approach. Well, thank you for that. So one of the things that maybe I personally wasn't clear on when I started working with you and even previous to that with my own parents, and then now with me, is what is the difference between an estate plan and a will or a trust? Or there's a lot of these words and terms going around. I don't know if they're synonymous or they are distinctly different, or can you shed some light on that?
Yeah, no, it's very confusing. You hear all these terms, you have no idea what it means. So estate, sometimes we hear the term real estate, right? So estate just means property. So an estate planning attorney is traditionally the attorney who prepares your will, talks about what happens to your stuff after you pass away, right? So an estate plan is a plan for what happens to your stuff. That often will include your will, right? That's often the document we think about. When I die, everything goes here, right? Very traditional. Most people understand what a will is. A trust is similar to a will in a lot of respects, but in some respects is a little bit more. So a trust is a private agreement that you have between you and someone else, often called the trustee, of what's going to happen to your stuff. And so a trust can be something you create in your life. It's something that you can be in control of while you're alive. It's something that can control what happens to stuff while you're alive, such as if you become incapacitated, or what happens to everything after you pass away. So an estate plan generally can encompass both a will, a trust. Oftentimes will also include like a power of attorney, advanced healthcare directive. But if you think of an estate plan as the overall umbrella term, and then underneath that term, you have all these little subcategories defining what we can do. So like there's almost like tools, right? So a will is one tool, a trust might be another one, and then the estate plan might be like the overall toolbox.
So you brought up a great point. What are, besides the will and the trust within the estate plan, What are the other really important components that people don't know they need to have until they need to have them? Like you brought up power of attorney.
When I create estate plans for clients, I have two goals in mind. Really, I want to make sure that my client is taken care of in case they become sick or ill, that we're giving their family or the people who they trust the powers that they need to make sure that that person is taken care of. And then when they're gone, making sure that the family is staying out of court and out of conflict as well. What tools am I using to accomplish those goals for my clients? A will can often take care of, who gets what when I pass away. But a will normally will translate into having to go to probate court, which in California is very time consuming, very expensive, that if you can avoid putting your family and having to deal with going to court, in and out of court, that's a huge gift you give to your family. So oftentimes in California, we're not going to do just a will, especially if you have assets. So if you have assets that might need some help getting to the next person after you're gone, often that's when we're going to start looking at a trust. The trust can do everything a will does. It says what happens to everything when you pass away, but it also can manage the assets while you're alive. So a trust is another tool to do in that regard. But again, I'm all about layers of protection, right? So if I have a trust, do I need a will? Because a trust will say who gets what after I pass away. So why then would I need a will? If you have a trust, your will takes care of anything that's not in the trust. So if the primary tool that we're going to be using is the trust, the will is that backup document. Well, if I forget to move something into the trust, the will is going to help me put it into the trust after I'm gone. Another tool we might consider using is a power of attorney. A power of attorney allows someone else to manage your finances while you are incapacitated or right away, just when you are alive. So it allows someone else to access your bank accounts, to pay your bills, to sell your house so that we can get the equity out to pay for your care. It allows us to do a lot of things in order to manage your finances when you can't anymore. Power of attorney is also backup to the trust as well. The power of attorney, there's some overlap between the trust and there's some things that can do the trust can't. But generally speaking, a power of attorney only works while you're alive. So if someone passes away, you can't say, well, I was my mom's power of attorney. Well, that's no longer good anymore because your mom's no longer alive. So the power of attorney only extends powers to someone else, again, while they're alive. It takes care of assets in your individual name, assets that are not in the trust, things that you might have to do in your individual name, such as signing a contract, right? So again, I'm looking at layers of protections. Another important document might be the Advanced Healthcare Directive. Who am I empowering to make medical decisions for me if I can't make that decision myself? Maybe I don't want it to be my spouse. Maybe I've had a number of cases where one spouse is a little borderline of capacity or maybe doesn't have capacity. And then you want maybe a friend or one child in particular to make that decision. So the Advanced Healthcare Directive where enables you to choose who that person is. Who's the one going to be talking with the doctor, giving the consent for surgery and medication? Who's making all of those very important medical decisions? So that's the Advanced Healthcare Directive. There's a lot of other little documents that supplement the basics there. One might be beneficiary designation forms. Who's getting what when I pass away to certain financial accounts? We might be looking at a HIPAA release because, I didn't get a doctor's note to say that, so-and-so can't manage their finances anymore. I go to the doctor and the doctor says, I'm sorry, we can't talk to you because of HIPAA. Don't we love attorneys and our laws? So I might include a HIPAA release to make sure we're not encountering that problem. So what I do as an attorney is I take a look at the family situation, what my client's coming to me for, and really creating a very holistic plan to make sure that they're taken care of. And again, I'm looking at layers of protection. So some of it might be overkill or maybe not necessary, but I'm not going to take that chance that this particular client is not going to fall into that 1% where this particular situation is going to come up. So again, I'm going to include all the protections that I can.
Right. Okay, that's great. And I think those are so many components that people don't think about. They think about just the money and who gets what. But I know myself, I bumped into the situation that you just described with the doctor, and they won't talk to you unless you have a power of attorney. And there's the health one, there's a financial one. So you need to have all those things buttoned up. So that way you can act and actually take care of your loved one when they need help, as opposed to start getting through all this red tape and delaying that.
I know the red tape
action.
seems really cumbersome, and why is it there? And the challenge is, you think if your family gets along great, and you don't have problems, but then there's always that one family where it's like, oh no, did I tell you that I wanted to talk to my husband about blah, blah, blah? I didn't want them to know. So the doctors are going to be a little hesitant. And so that's why we have those laws in place. The challenge is it does kind of create that red tape. And so this is what the plan is intended to address, right? How do we make things easier for our families?
Well, this kind of dovetails nicely. So now that we know the pieces of it, when should people start thinking about putting an estate plan in place? Especially, I mean, is it, as early as possible, middle age, when you're a senior, if you don't necessarily have kids or money, or like there's a lot of these things. So when should be the first time that people should start maybe putting something together? And then, as you had mentioned, the families, dynamics change, things happen. Like, how often should you then update it or renew it? So that's two-part. When should they start, and when should you revisit?
So I often joke that estate planning is here on the to-do list. So for those of you just listening, I'm holding my hand, relatively low. And then this is where dying is, and it's just above putting your estate plan together, AKA we may never think about putting our estate plan together. And I get it. It's not easy to think about putting this plan in place because, again, people often associate this with death and dying, and it's not necessarily an easy thing to talk about. To your question in terms of when should you be thinking about this, really, theoretically, age 18. As young as 18. Now, granted, 18 years old, I have more student loan debt and more bills than I do of assets. So at age 18, you don't necessarily need the same type of estate plan that you might need when you're older and we have more assets. So an estate plan, again, is just a plan of who's taking care of you if you can't take care of yourself, and how is the money and all your assets are being handled. So it might not be as a big or complicated plan, but you still need a plan at age 18. Because at age 18, you're now a legal adult. Your parents can no longer make your decisions for you. Your parents no longer can talk with your doctors without your consent, right? So those problems that you're describing, you can still have that at age 18. So you need to start thinking about this early. Now, I don't necessarily mean run out there and panic and get stressed out about it. You need a plan in place. So the plan evolves as our life changes, right? So you might want to revisit your plan when you get married. Oh, now I want to include my spouse. I need to update my beneficiaries to make sure my spouse is going to be receiving my life insurance or my retirement accounts, right? Because I want to make sure they're taken care of. I have kids. I need to make sure the kids are taken care of. And this is where a lot of my clients really start coming to see me at that point. It's when they have little kids. I have something called a kids protection plan, where it's a really robust guardianship plan for the kids in case something happens to you. Because the last thing I want is just something to happen to the parent, and now the kids are going to foster care, even for a day, while they're sorting out who's taking custody of the kids. I don't want that to happen. So that I have a plan that's intended to try to address that problem as much as we can beforehand. What happens to everything you have that you want to leave to the kids? The kids are not 18 yet. They can't own property. So if I want to make sure they have money for college, how is that being managed? Right? This is where we start planning this in our estate plan. Our lives will change again as we begin to age. Who's going to take care of me becomes much more important. We tend to go to the doctor more often. So people in our lives move. So I may be choosing my oldest child because they live here, but then they move to Oregon and they're no longer close. So now I need to switch out who I wanted that person to be. So kind of to your second point, how often should you revisit your estate plan? There's naturally triggers in our life that will make people think about their estate plan more, right? When you get married, when you get divorced, when you acquire your first house or other significant pieces of assets, when a child is born, a grandchild is born, you have a big health crisis. Someone else in your life had a big health crisis. Someone in your life had passed away. Those are all natural times that people start thinking about their estate plan. But generally what I recommend to my clients is come see me every 3 years at least. It seems really soon. Like, I feel like it was just yesterday. Time moves so quickly. And you're
Yes.
to come in 3 years. And it gives me a chance to connect with my clients again. We get to revisit. Do we move everything into the trust that we wanted to move? Did the laws change? Did our families change? Just to check in, just like you go to see your doctor for that annual physical, just check in with your attorney. It may be that everything's good. Great. Come see me in another 3 years. So because plans fail because they become too old. I can't tell you how many times a client come to me and their plans are 20 years old. They're like, oh yeah, our lives are radically different. Well,
Right.
glad they're coming to see me and updating their plans, but if they didn't, the plan that would be implemented is not the plan they wanted. And that essentially means the plan failed. And so I want these plans to work when they're actually needed.
Got it. So it's a real kind of living document that really needs to be updated. It's not a put it in the drawer and forget about it until, pass.
The most common trust I put together for my clients is a revocable living trust because it's meant to live with you and change with you as your lives change.
Got it. Great. That's a great point. So you mentioned 18 years old is the first time you should start thinking about it. Now, out there in the world, there's, online estate planning and trust. I would imagine there's some obvious things, but what are the main differences between doing something, a canned estate plan online where you fill in the forms like, what's that?
The do it yourself, the LegalZoom and all those other.
Yeah, exactly. Going to like someone like you to then actually do it in person and go through that process. I mean, what are the biggest differences with that?
The big difference is going to be getting legal advice. It's understanding how these documents work, how to use these documents, how to make sure the documents are really optimized for what you want it to do. I once had a client come to me, thought their situation is very simple. I'm single and I have one child and I just have one house. And it should be so simple that I should be able to do this myself. And so she went online, she did a trust herself, and then she started having doubts about what she did. So she come to see me. It's like, Jeanette, just review this trust. Tell me if I did a good job or not. And I'm looking at the trust that she drafted. And she told me her number one goal was to make sure her daughter is taken care of if something should happen to her. That's all she cares about. Just make sure that my daughter is taken care of. And the trust says, okay, when I die, everything goes to my daughter. Okay, that part's good. And if my daughter passes away before me, I want everything to go to my daughter. They had that circular language, right? Because in her,
Right.
what's important? I just want everything to go to my daughter.
Yes.
She didn't really understand the question in terms of, well, what happens if your daughter's not around? Where should everything then go? So she just put my daughter, right? Because the challenge with do it yourself is it's very much a question and answer situation where they're not going to tell you whether or not you gave a wrong or right answer. It's just filling in the blank in this template that may not work. So a lot of these online templates are designed for a very specific situation in mind, and there's no additional protections. They're going to assume that you're healthy. They're going to assume your family gets along. They're going to assume you know what you're doing. They're going to assume that your family knows what to do. They're going to assume you all of the steps needed to make it work. They're going to make all of those assumptions. And most people, those assumptions will not be true. And so that's where I come in really as the attorney, is I help guide the clients in terms of how to prepare this, how to make it work. Because if it was just a matter of filling in the blank of a template, yeah, do it yourself. Now, hopefully you'll find a good template, although sometimes that's even questionable. I've seen a lot of bad trusts out there, even prepared by other attorneys. But if it was just a matter of filling in the blank, then yeah, you should be doing it yourself. But the reason why you see an attorney is to get that legal advice, is to get that guidance, to build a relationship with someone so that you have someone to ask your questions. Because it's my job to ask questions of you too. Like I ask so many questions of my clients, questions that they often tell me I never would have thought to ask this myself. Or you're coming up with protections to include in the plan that I never would have thought to include, because I never would have occurred to me that that might happen. I was reviewing actually a trust prepared by another attorney, and the trust left was by an aunt. She had no kids, so she wanted to leave everything to her nieces and nephews. Her one niece was disabled, so she particularly wanted to make sure this niece was taken care of. Aunt passed away, and we're now administrating this trust. Seems relatively simple, except that the niece is disabled, as I said, and she's receiving SSI benefits for in-home care because she's bedbound due to her disability. And because she's receiving SSI benefits, you can't have more than $2,000. And so when she received this inheritance from her aunt, she could lose her SSI benefits.
Right.
And that would be okay if the trust had the right language. Often what I do in my trust is I say, okay, if any of my beneficiaries are receiving needs-based government benefits such that receiving this inheritance would cause them to lose their benefits, we're going to do this with their inheritance instead. We're going to keep it in the trust. It will never go in their name. If it never goes in their name, they don't lose their benefits.
Right.
Very important protection to include in a plan. And I do this for all of my clients, regardless of people's situations, because I don't know what's going to happen tomorrow to this beneficiary. If they get into a car accident, or I just don't know. I don't have that crystal ball to be able to protect or to predict what's going on. And so I'm going to include all of these protections in my plans, address all of these different what ifs, because I don't know if that what if will happen or not. And so I include a lot more protections. It's more holistic. It's more comprehensive. The other challenge, I know that a lot of people say, well, attorneys, is so long and complicated. I don't understand this. And to some extent, I get it. It's a lot of legalese. And so that's why I'm here to help translate it, because the documents are not written for the layperson. It's written for the courts in case there's a conflict. And so I want to make sure, again, people are staying out of court, they're staying out of conflict. I ask all the questions. I had a client come to me where he came in and said wanted to disinherit a child. And so I'm asking the questions. Tell me about your relationship with this child. What's going on? Well, I just feel like I've helped them out so much during their life that it's just not fair to the other kids that I want to leave, I've already helped them out, everything that they would have inherited when I'm gone. So I'm just going to leave everything to their kids. I'm like, okay. And we start talking more, and then they, again, are reaffirming what they want and confirming they understand the ramifications, consequences of this decision. And later they came out, well, I kind of feel guilty. I'm like, what do you mean? And they said, well, just they do talk with me and spend a lot of time with me. I'm like, well, tell me more. And it turns out this child is living with them. And as a consequence of their plan, the house will be sold after they're gone. So if they're disinheriting this child and the child has needed a lot of help during life, are you okay with this child getting kicked out of the house with no money to start fresh and possibly becoming homeless? Are you okay with this? Well, that's why I feel guilty. And then I'm like, well,
Right.
this is obviously something you need to think about in terms of whether or not this is a plan you want. You don't necessarily have to leave them as much. Maybe there's some compromises we can make in here, but that's what I do with my clients is I talk through their plans. And because I have the experience in dealing with different family dynamics, I ask the questions because I am intensely interested in how is a family going to cope when you're gone? Right? So that's a huge difference in working with me versus another attorney or even trying to do it yourself is you're getting that counseling, you're getting that advice.
Right.
And again, making sure that the plan works. I can't tell you how many plans I've seen that they did it themselves, but they didn't move the house into the trust because they didn't know how to do it. And then the plan failed. And so I'm here to try to make sure that the plan works when it's actually needed.
Right. Well, I know, I've referred people to you and I tell everybody that you are extremely thorough, and I'm sure during the process it's excruciating, but you know what? The end product is what's most important. I mean, people do this with their taxes. You can go online and do your own taxes, but if you have any complexity, you don't have somebody to say, well, what about this? What about that? If you don't do it correctly, there's going to be consequences. And I think with something like your estate plan, the consequences could be really dire, just like you had described, all of a sudden this their kid, adult child is now out on the street, and it all makes sense on the front end. It's like, oh, I've already given them so much, but what happens when you actually pass? And then you know and maybe the siblings aren't so forgiving or whatever, but it's great that you're taking them through that process. Right.
The question, are you okay with this? If you are, then great, we'll do this plan. But if you're not, what can we do to make it a plan that works for you, that what you want?
Right. So we've been talking about all the reasons why you should have a plan, or the different components of it. Now, if somebody doesn't see this podcast and immediately pursue putting something in place, like what happens if you don't have an estate plan or a trust or anything like that? It's just people just haven't thought about it, and or like you said, they're kicking the can down the road, and something tragic happens. So what happens in general? I mean, every situation is going to be very specific, but in general, if you don't have something in place, what are the consequences of that?
Gosh, that would be like my worst nightmare.
Yeah.
And I say this because I almost want to cry when people call me in this situation, because it's in my mind a little heartbreaking. So if you're still alive and you don't have a plan in place, and that means you don't have a power of attorney, you don't have a trust, you don't have advanced healthcare directive, and you lose capacity, you have dementia, you have Alzheimer's. I had that happen to both my grandfathers, where they both had dementia. And if you don't have a plan in place, the question is, well, who can access their bank accounts to make sure they're taken care of? Because if you don't have a plan in place, here's what happens is we have to go to court and file for a conservatorship. A conservatorship is like probate, but you're still alive. It's where a judge is now going to decide who's that person who's going to manage your money. May not be the person you would have chosen. And now the court has to oversee everything. Multiple court hearings. You may have to post a bond. Just like you get arrested, you go to jail, you have to file for a bond. You have to do the same thing in probate court, because the court doesn't know if this person who you didn't choose is going to take all of your money and run off to Vegas and gamble it all away or steal it. So they're going to make them post a bond so that there's some money to recover against if they decide to steal the money. And then they have to account to the judge all the money that comes in, all the money they spent, and get court approval for everything for the rest of your life. And if you didn't think that was bad enough, the attorney's fees. So your family member who's applying for the conservatorship hires the attorney, has to pay that attorney out. And then the court will appoint another attorney to represent you to make sure your interests are protected as well. So there's two attorneys involved in an uncontested conservatorship. No one's fighting anything. And so you're looking at spending tens of thousands of dollars in doing a conservatorship. And this is just when you're alive. If you have no estate plan and you pass away, they were dealing with the probate court. If you have any sort of assets, especially real estate, anything without a beneficiary designation that's more than $180,000, and there's not in a joint account, we're talking about having to go through a court process. Because if I pass away, and let's say, for instance, I'm married, I'm elderly, I'm married, and I have a joint account with my husband. My husband passed away, and I never go around to updating beneficiaries. And when I pass away, there's now no beneficiaries listed on my accounts. That's now going through probate. I have a house that was in joint tenancy or community property with my husband. He passes away, okay, that everything comes to me. And now when I pass away, now that's going through probate in order to go to the kids. Uncontested probate, or looking at spending, I don't know, with real estate nowadays, you easily can spend over $40,000, $50,000 in an uncontested probate just to transfer assets from a parent to a child, even though it's very clear that everything is going to the children. Yes, everything will go to the kids. It just won't be automatic. It will require court hearing, multiple court hearings, multiple court orders to do so. And so this is why everyone says you need a trust, you need to avoid probate. It's because of that. But even between married couples, sometimes the titling of things are not where you thought it was. I reviewed a lot of cases where they thought things were titled one way, where everything would automatically go to the other spouse, and it was not automatic. Where even after one spouse passed away and they thought everything would go to their surviving spouse, it didn't. And we still needed to go to court. And so these are reasons why, like, people say, oh, I'm married, I don't need to worry about the estate plan. Everything I have will just go here. And it's true that it might go there, except it might not be automatic. You might still have to go through that court process. And so that's why generally I recommend people, in particular, if you have assets, if you have a house, I don't care how much the mortgage is on the house. If you have a house, if you have significant amounts that you saved for your retirement, there's more at risk because you have more stuff that you need to protect, worth going to an attorney. If you have complicated family dynamics, your kids don't get along. That's often the case. Maybe one child's more responsible than the other one, so I'm going to choose a responsible child. But now that stereotypically the younger child, the one who's not as responsible, is perhaps resentful of the older child, is skeptical, and conflict starts happening. Those are situations where you probably should have seen an attorney to help walk you through alternatives of how to avoid that type of conflict. Blended family scenario. I have children from a previous relationship. See an attorney because there's going to be conflicts that might come up. Just in general, just kind of see whether or not your case falls into simple. A lot of times people think they have simple, and by the time I hear it, I'm like, that was not simple. Yes. So it's almost misleading in terms of what we think is simple versus legally what is simple.
Right. So that's really important point. So you might think going through a estate planning process is complicated and a hassle, but that doesn't sound like that's anything compared to what it could be as far as not only the expense, but just the time. I mean, as you were describing, going through the conservatorship and all that, not only is that money, but it's also time, that it's pushing out the person's ability to actually help them, especially if their money's locked up in an account that they can't access. So in the meantime, they can't help them, even if they want to help them, because they just don't have the authority to help them at that point. So those are all really great points. I think we've covered like a ton of stuff here, and I appreciate that. I mean, there's so much more. I just thought, is there anything kind of a big point that maybe we haven't covered that people should know about estate planning or will and trust? You covered a lot of things, but I just want to make sure we don't miss any big piece.
The most important piece that we haven't talked, we talk a lot on money and finances, but I think the most important part is the family, and it's the values and your legacy. And the legacy, I don't mean you have to like make some huge donation. What I'm talking about is our family history, our values that we want to share, like recording your memories so that your family can look back on that and hear your voice and see you. I think that's important, and it's documenting all of that, right? And so, part of what I like to do in talking with clients is addressing that piece of it as well, because it's more than just money. It's really what's important is the family, right? And so how do you make this estate plan really work, in my opinion? It's not just the legal documents. It's not about the documents at all. It's about everything else, right? The documents often represent like a physical manifestation of what I do, but I do so much more than that. And so whether it's talking through legacy videos with the clients, how to deal with photos, about, perhaps mending relationships with people. I have people like, are you a life coach? Are you a therapist? I'm like, no, I'm not any of those things, but I'm interested, and I want to spend the time with my clients to make sure that that's taken care of, because to me, the most important part of the estate plan is the people. It's not about the money or the documents, it's the people involved. And so creating an estate plan can be really a gift that you're giving to your loved ones and to your family, because they're not having to, like you said, spend that time and all of that time really dealing with all this stuff. Right now, to file a probate case uncontested probably will take 18 months, and no one's biting.
Yeah. And so, yeah, if there is conflict, it could probably go even much longer. So that's if everything is all lined up and there's no problems. Wow.
Yeah, and it's just, after years of dealing with litigation, I don't even want to deal with going to court anymore. I can't imagine the average person wanting to go to court every few months to do a status update or do an accounting or whatever else needs to get done. And so my goal again is to help keep families out of court, out of conflict. Even for people who's like, take myself, I'm single with no kids, and so a lot of times, talking about legacy can be challenging for those of us with no family, right? Well, who am I leaving a legacy to? But it's looking at the lives that you touch. For my clients who are elderly and single with no kids, then I'm looking at what is your circle of support? Because I've had a handful of people come to me and say, well, I don't have anyone. I don't have family I can rely upon to take care of me. What do I do? This is where I work with people in the community about creating that circle of support, whether it be hiring a professional fiduciary, a care manager, exploring with them other people in their lives who want to help but haven't been invited to help. It's about creating that circle again, because it's about the people. It's not about the document.
Yeah. Yeah. Well, you know what? We've come exactly full circle because that's what we talked about in the beginning is like the estate is the stuff and the property. But this is really about the planning is really about taking care of the people and putting the people first in a heart-centered estate planning, which I love. We're going to put in our show notes and everything, all the different ways that people can contact you, Jeannette, because I think this is probably going to hopefully create a lot of interest because people, this is going to create a lot of gears turning in people's heads on, oh my gosh, I never thought about that. I'm going to really need to start to explore getting this in place so I don't get caught up in all those pitfalls that you just mentioned. But we'll have all the ways that you can contact Jeannette Marsala Law Firm. And I just wanted to say thank you again, Jeannette. This has been super enlightening. Every time I talk to you, it lights another fire under me to get going and contact you for all of my specific needs around estate planning as well. So thanks again so much for being on the Synergy sessions. All right.
Well, mine. So I'm always happy to chat and help. So thank you.
Yeah. Well, thank you so much. Everybody reach out to Jeannette if you have questions. She's a wealth of knowledge and very thorough. She will not steer you wrong. Thank you for joining us on the Synergy sessions. We know you have a lot on your plate, so we really appreciate you spending the time with us today. If you found the information in this episode useful, please reach out to the guest or the resources in the show notes. I know they would appreciate it and would love to help. Also, if you have an idea for a future episode, please reach out to us on Instagram or Facebook or email us and let us know. We'd love to hear from you and provide information that's useful. Lastly, please remember, you don't have to do this alone.